Welcome back. You're watching HFO-TV. HFO-TV is co-sponsored by the construction, repair, and restoration firm J.R. Johnson, the real estate law firm Janik, LLP, the tax deferral accommodator Butler Exchange Group, the mortgage banking firm Gantry Incorporated, and forensic building consultants providing building structural science services.
Welcome back to HFO-TV. I'm Greg Frick, partner at HFO Investment Real Estate. And here with us today again is Ciaran, partner at Janik. Thank you. We've had you on many times before. As we were kind of talking off camera, there's never any rest for landlord-tenant law in the Oregon for the last few years. So
Absolutely.
I think this will be kind of a regular occurrence having you on, kind of giving updates, since it seems to be changing on a weekly or monthly basis as to what's in place, what's not in place. So thank you again for taking the time to join us.
I'm very glad to be here and happy to help try to dissect everything that's going on out there.
So maybe we can talk a little bit about kind of what's changed. I know there's House Bill 4401. Multnomah County did an eviction moratorium extension, and they just pulled it back this week or last week. Maybe give some insight as to where we are today. This is first part of January. Again, we're not predicting what's going to happen in the future, but kind of give us the lay of the land.
Sure. So as I'm sure all your landlords remember, it's been a wild year. We sort of started with some emergency declarations by the governor, by the county, way back at the beginning of 2020. Eventually, that kind of got codified into what was House Bill 4213 back last summer, which kind of formalized a eviction moratorium and provided an expiration date of September 30th. And then just before that eviction moratorium was going to expire, the governor issued her order 2056, extending the prohibition through the end of the year. In the meantime, Multnomah County passed a couple of ordinances extending its own moratorium. And Portland, of course, lowered the threshold to its requirement to provide relocation assistance to any raise in rent rather than the 10% threshold that they'd had in place before. So this is kind of the backdrop of what was in place at the end of last year, end of 2020.
It was a busy year in 2020 for landlord-tenant law.
It's a crazy year with things changing nearly every month. And by the time you could digest it and figure out what you're supposed to do, the rules probably changed again. So it's a great year to get in touch with your lawyer and get some solid advice. And to play it safe in terms of trying to evict somebody and trying to those sorts of things. It's better safe than sorry in these, because all of these measures, whether you're talking executive orders or the bills or the ordinances, they all have pretty draconian consequences for doing something that the government doesn't want you to do. Basically. But all of that was the backdrop. And then in December, in the special session of the legislature, we got House Bill 4401, which was adopted. It passed by the legislature on the 21st of December and signed by the governor on the 23rd and took effect immediately. And it does a few things. And rather than try to go through the entire litany of things that it does, I thought we'd try to compare and contrast with what landlords are doubtless familiar with from 4213 earlier last year.
That'd be perfect. Yeah.
First thing, we've got new timelines. We have an emergency period that was extended by 4401 officially through December 31, 2020, and a grace period. That's the period during which the tenant can repay any unpaid rent from the emergency period, which started back in April of 2020. Any of that back rent they have until the end of March to repay. Now, I'm saying that that's going to apply to almost nobody because that's sort of the minimum extension. And what 4401 does in addition to that is extend both of those periods, both the grace period and the eviction and the emergency period, through June in almost every circumstance. And we'll talk about exactly sort of what triggers that. But the takeaway right up front for landlords is that unless they thread the needle in a very specific way, and the tenant doesn't decide that they want more time to pay, which what tenant isn't going to decide
exactly.
more time to pay, the end of both the emergency period and the grace period is going to end up being June 30th, 2021.
So not March, even though you'll see things in March. It's such a tight window.
Yeah, that's exactly right. You'll see that in some cases, the emergency period has technically expired because the tenant hasn't provided the next thing we're going to talk, well, two things we're going to talk about, a declaration that the reason that they're not paying is because of, whatever. All they have to do is say that they're not paying because they've had some adverse effect. That doesn't even necessarily have to be COVID related. But we'll get to that in just a moment. I think big picture, we've got emergency period in place for the first 6 months of 2021 and the grace period extended through that time as well.
So Ciaran, is that all statewide?
Yeah, this is 100% statewide, and we'll talk about Multnomah County in a little bit, but this applies everywhere in Oregon. So everybody's got to be aware of this and looking into how to deal with it. So we'll talk about a little of these things, but one big change in House Bill 4401 is a little bit of direct relief for landlords. It allocated $150 million to a landlord compensation fund. And essentially the basic deal that the state is proposing is this. You forgive, the housing provider forgives 20% of unpaid rent, and the state pays the other 80%. And there's going to be a whole application process for that. The state is still setting that up. It's expected to launch later this month. But there'll be a process where the landlord submits a whole bunch of information to the state. The state processes it, and if it's all approved, then they pay the money out. So that's the basic deal. The precise contours of all the things that you have to say in the application and which landlords are going to get priority over other landlords. There is going to be some priority because we know the hole in the water created by this whole thing is bigger than $150 million. But so there's going to be priorities and things like that. If folks are interested, and I assume everybody is, on staying right on top of that, there's the most direct way is to sign up for the state's email updates about the launching of that program and the contours of it. But big picture, it's this, you get 80%, forgive 20% kind of deal, and you're going to have to document that for the state. And one of the, so that's the big carrot, I guess, for housing providers.
Yeah, there's a lot of questions. I've got a lot of questions with owners that are asking, what if, they say they're going to prioritize smaller property owners. So then how does that work? If I submit, what if I don't want to submit and go, there's this, it's very, I think, like I said, I think they're talking about opening up the portal for that from the state. They're saying by the end of January, we'll see. But as I was telling somebody, I wish they just wouldn't call it a landlord fund. It's a, tenant obligation fund. But, there's a question, as we said, it's a drop in a bucket, 150 million. Sounds like a lot. It's going to go, really fast. And again, if they prioritize smaller property owners, you may have issues. As we try to say to the state, what do you say to that tenant that's in a 20-unit building? Sorry, you don't qualify. You're going to still owe that, that debt you've accrued since, whatever, March, April, May. It just doesn't seem like I think it's great they're getting it out. I think more relief's better, but if that's their solution to the issue, it's not kind of a catch-all. So
to a little bit of credit, I think they designed the program, they've designed it in a way so that if they get some federal relief, so that that 150 million turns into 300 million or whatever it might turn into, that they can use that same apparatus and avoid having to have a whole separate application procedure. So there is a little bit of forward thinking there, but it's, I guess, better than nothing. No,
that's what I think. It's better to get it out instead of just sitting on it for 6 months. It's better to get as much relief as we can. It's got to be more encompassing. As I try to say to somebody in Salem, the one size fit all is not going to work. There's going to have to be different tiers on how you do assistance, and hopefully they look at it that way. So.
Yeah, well, and along with that 150 million for direct to the housing providers, there's another 50 million, I think, that was allocated for rent assistance. So you can, your tenants may be directly eligible for that kind of assistance, which would benefit the landlord if it gets paid through. So look for more details of that to come out very soon. Certainly by the end of January is the expectation. A big part of how that application process is going to work is going to be based on these new tenant declarations, and this is a new form that's prescribed by HB 4401, and it basically allows the tenant to say, look, the reason I can't pay is because of some COVID-related impact or some other unrelated impact, but as a result, I can't meet my rent obligations.
Is this similar to the declaration they had to make for the CDC eviction moratorium?
It's a little bit like that. But it is its own form. It's worth. It's not just worth it. It's mandatory to use the prescribed form.
Got it. Okay.
And the reason, whereas before, we saw it before, I think in commercial tenancies, they had to provide some sort of evidence to their landlord back earlier this year for the commercial relief. This, 4401 is just residential, so we're not talking about that anymore.
Okay.
But notably before, the resident didn't have to say that they were having any adverse effect. They could just not pay the rent. And now they actually do have to sign a sworn statement that says, they've suffered some change in circumstance that is not allowing them to pay the rent on time.
Got it.
Why does a landlord want to see those? Well, there's first, let's talk about the tenant first. Why does a tenant actually want to go ahead and sign that? The reason is because by signing that and sending it to the landlord by whatever means they think is likely to get there, the tenant gets that jump to the June 30th date. So they automatically get that extra 3 months of the grace period and 6 months of the emergency period.
So that's the trigger to put it, that basically invalidates the March moratorium, puts it to June if they fill out the form.
Exactly. From a tenant's point of view, as soon as they sign one of those, they get pushed out that way. From a landlord's point of view, you might wonder, well, why do I want to bother doing all this if I'm just, why don't I just sit back? But from a landlord, you collect those statements, and those are going to be a big chunk of what you submit to the state as part of your application for the 150 million that we just talked about. So there's actually, they finally put in some motivations to provide both parties an interest in getting this notice sent out and filled out and returned to the landlord on a timely sort of basis.
Is the landlord property owner need to get that to the tenant, or can the tenant do it on their own and give it to the property owner?
It can go either way.
Okay.
It's if you remember back under 4213, it's sort of there was an optional obligation for the landlord to send a statement of the rents that were currently due, a reminder that those rents were still owed, and that sort of thing. And that is still allowed. But if you send one of those now, you have to include one of these declaration forms as well as some other information to your tenant. And that might actually be the perfect mechanism to distribute these to your tenants. Say, look, here's a statement. You still owe, rent for these 6 months that you didn't pay. You're still going to owe that rent. Here's a declaration. You might offer a payment plan at that point. You have to say that it's optional expressly, but you might say, look, you're going to have this grace period, and if you fill this out, that grace period will last till the end of June, but let's figure out a way for you to work out some of this or some sort of compromise here.
So then if they don't fill it out, you don't get that affidavit back, then in theory they're stuck onto the end of March for the. Right,
they're stuck on the March, but just because they don't send it back immediately doesn't mean that they can't send it back later. And in fact, you're also required to submit that declaration if you serve them with an FED. complaint, they can do that. You can get all the way to court, and as long as they have signed it before that first appearance, the court is obligated to kick the FED out until.
Yeah, so more likely the tenant's going to sign that at some point if you're going through the process. So you might as well just assume it's going to go through June.
Right. Assume it's going to get signed, and approach it as sort of a teamwork thing with your tenants. Like, look,
Right.
this is the best way for me to be able to get forgive some of your rent and get it get us paid by the state.
Okay.
It's an opportunity to really build that sort of trust relationship with tenants that are.
Well, hopefully it opens up the communication, because I think, from a property owner standpoint, I think one of the biggest issues we've had in 2020 was just, the tenants and property owners are trying to work together. I think, as I've told people, majority of property owners are not trying to put people out on the street. And it's just, but I think the way things were put in place in 2020, the lack of communication, especially in Portland, where the tenant didn't have to say anything, and it was just this, kind of in the dark thing. I think hopefully this will enable people to, at least sit down, maybe not next to each other, but talk about, here's a plan, or this is what you can do, and what can I do to help you out? So hopefully it opens up that line of communication.
Yeah, absolutely. I think it's a good thing that way, in that it encourages that, and it gives both parties financial incentives to actually participate in that. Landlords that are interested in sending those notices should absolutely read through the statute, make sure that they comply, because there are very particular requirements with all the information that has to be included with that sort of a notice. So make sure you've got to have this form declaration. You've got to have an information sheet about tenant resources. There's a bunch of different things that are listed there. So have your attorney look through that, or you get a reputable form from one of the.
No, in these day and age, we advise everybody, if they're not using a management, get an attorney to look at this stuff, because it's this is not 1970s where you do it on the back of a napkin. So it's very specific on what needs to be delivered, when it needs to be delivered, what has to be delivered with the notice in terms of tenant right information and all that. So again, for people out there, get legal advice that you make sure you're doing it right. If you've got third-party property management, to ask them, but again, make sure it's done right, because the missteps on these are very costly for everybody.
And related to that, actually, part of the motivation, I think, early concerns were with landlords waiving rights by accepting partial payments or things like that. That all was fixed a little bit by 4213, and has been those fixes have been continued in 4401. So there's no waiver of any rights by the landlord accepting partial rent for claims for back rent or for other violations of the lease. So even if you might have some other basis for evicting the tenant, you don't waive those by accepting partial rent during this period. A few other things that are still there. The statute of limitations for cases brought against tenants is extended through, I think, the end of August, so that it's told. So that if you would have had to bring a case now, but you can't because there's a moratorium, you have until the end of August to do that. A couple other changes that have come through that are helpful. One is, before landlords had the option, at least, to try to pursue just a suit for rent, not an FED, not an eviction, but just to sue the tenant for unpaid rent. And now that's expressly prohibited. So if you were somebody who was interested in pursuing a small claims case before, you may have done that in the past. You can't do that now. That is until after the expiration of the emergency period and the grace period. So
you're restricted from doing a small claims. Now, is that on existing tenants, or what about tenants that were in your building and moved out in January with a amount owing and never gave a declaration or anything like that? What is the option for? Not that I think a lot of property owners are doing that, but just in case.
Yeah, unfortunately the statute isn't 100% clear there. So to be on the safe side, I'd wait until afterwards. Now, there is a little bit of relief for landlords that find themselves in that position, which is that HB 4401 expressly allows the landlord to use the security deposit or the last month's rent towards unpaid rent obligations from the emergency period. So if you've got a tenant that didn't pay their November or December rent and then moved out January 1, you've got a security deposit, you can credit that.
Is that in Portland too, or is that statewide?
That's statewide.
Okay, got it. Okay.
Yeah, you want to be careful in Portland because Portland has its own requirements that way. But at least under the state law, that sort of crediting is allowed.
Got it. Okay.
A few other changes that came through with this: the notice periods that you might otherwise the old 72-hour notice period is extended to be 10 days instead of 72 hours.
Okay.
And the lesser used 144-hour period is now extended to be 13 days. So those sort of prior notices that you give for eviction or other breach of the lease, there's additional time now required. And
again, when you give this notice, say to a tenant, now you still have to give the declaration, I'm assuming pamphlet with them. Yeah.
Right. If it's for eviction, any sort, especially if it's for non-payment, then you're going to need to do that, and you really shouldn't be, unless it's one of these bizarre circumstances where it's April 1st. We've gotten past the minimum grace period, and you're seeking back rent on April 1st, and they haven't given you a declaration already, then you still need to include the declaration with the summons and complaint. And there's actually new prescribed forms for FED complaints and those sorts of things. Landlord has to swear that they have submitted the declaration, that they haven't received a response back from the tenant. And if at any point you fail to if you send that notice and you haven't included the declaration form, then the court, then the emergency period automatically extends to be the June 30th thing, which is again why landlords should, from a practical point of view, just assume that it's June 30th and work to get as many declarations as they can for their support. So that's kind of the scope of HB 4401. It cleaned up a lot of things, it kept a lot of things, and it's extended the dates, I think most importantly, along with setting up this landlord fund. But of course, the state is not the only government entity that has waded into these emergency regulations. Multnomah County, I think famously, was the first to mandate this sort of grace period, and they adjusted their ordinance a few different times, but most recently, just last week, they adopted Ordinance 1292, which rescinds the prior Ordinance 1287, and basically attempts to put Multnomah County in harmony with the HB 4401 that we've just discussed.
So Multnomah County, as we talked about a couple months, well, I forget when it was, in December, I think, came out and did an extension of the moratorium to, yes, I think it was June, and now they've rescinded that, but in essence rescinded that to be more in line with the state, which, as we just went through, in all likelihood, because of what the relationship, more like, you can say it's due March, but it's a very fine line where it's going to be the place. It's going to be to June, but Multnomah County's now pulled back and is going to be in line with the state.
That's right. Yeah, they I think they get extra nervous early, so they passed their extension ordinance on December 17th. A week later, 4 days later, in the legislature, at least, they passed HB 4401. And while both were in effect for a while, it made for some very bizarre deadlines where you had outside Multnomah County, there'd be a deadline of January 1, and inside Multnomah County, it'd be January 7th or something like that. And July 6th versus July 1st. And all of that, is small victory, but at least a little assurance that there's just one less group of ordinances that landlords have to wade through and figure out for themselves. So that's that. The city of Portland itself doesn't have its own eviction moratorium. Early on, they sort of passed some resolutions commending Multnomah County and then later the state, but they haven't purported to put in their own separate eviction moratorium. They have, however, back in September, as I'm sure the landlords are aware, enacted a temporary amendment to the relocation fee ordinance, such that any increase, not the normal 10% increase, but any increase in rent that would take effect between September 16th and through the end of March of 2021. Any rent increase that would take effect in that period will trigger a landlord's obligation to pay relocation assistance, assuming that the other criteria for having to pay relocation assistance are there.
Now, Ciaran, is on that, if RUB charges, utility bill back charges, is that included in that? Is that, if my utility bills go up and I'm gonna, we're doing a percentage or I'm doing a set fee with tenants, if I want to institute that increase, is that trigger that, or am I better off to wait until, after March to do something like that?
So under the state definition, and I realize this isn't, the answer is, to be on the safe side, is better to wait until after March 31st to implement that. The longer answer is that under the state definition of, for the states where rent control, there's the definition of housing costs includes utilities, and
Got it, okay.
Portland is likely to do the same thing. The city itself is likely to take that sort of more aggressive view. So I'd just be, again, the consequences are so draconian that even though there may be arguments to the contrary, I'd err on the side of not increasing. Let's see. I want to make sure there's nothing that we missed. There is one small change, is that to the evictions that are currently allowed. You can still evict for cause, right? You could always evict for cause other than non-payment. But the legislature expanded the number of landlord qualifying no cause reasons that a landlord can evict for, and now you can evict after proper notice, et cetera. If you are renovating a unit, if you're demolishing a unit, or if you are evicting somebody for you or an immediate family member to occupy as a primary residence. So those, it's one of the subsets of the ORS for whatever it is, 27, I think. There's an expanded group of reasons that a landlord can.
So renovation does fall underneath the ability to get a tenant out if need be, or
right. Provided you give the required notices, et cetera.
Right. Well, I want to thank you for taking the time to do this. I'm sure we'll be talking soon, as we've just talked about. There's been a lot of changes since, like I said, almost, Multnomah County saying yes, then no. It's just all over the place. But as we've said before, Ciaran, for people out there, talk to a tenant landlord attorney, or make sure you're doing your forms right, your notices before. Do it beforehand. Don't do it after. It really makes it tough for Ciaran to do his job when you call him and say, "Oh, by the way, I just gave this tenant this notice. Did I do it right?" Do it before you're going to give them, plan ahead, because again, the penalties for property owners are very, very stiff, and there's a lot of places to slip up. So you're better to take maybe an ounce of prevention on the front end and making sure it's done right, either with your property management firm, your attorney, and making sure the notices are done correctly. Because if you don't, it can lead to a lot of issues down the road. So
it's absolutely correct. And Greg, thank you for having me on. I wish everybody out there listening, the best of luck in navigating this extraordinarily difficult situation. And I'm happy to help any of them in any way I can.
Good. And if you want to get a hold of Ciaran, the contact information is below. And again, thank you for taking the time to do this. We'll see you again, I'm sure, soon. Like I said, this has been an ongoing kind of theater that we're in, but we'll try to get through it. Everybody, please be safe, and we'll see you next time on HFO-TV.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.